time and space of critical legal pedagogy. So I've been writing over the past few years about the need for what I've been calling a critical legal education. So I just want to give you some background on that. So probably around 2012, 2013, they emerged in popular and legal discourse the idea that legal education was in a state of crisis. Apparently, judges in particular, but also senior lawyers, advocates, and so forth were complaining that the kinds of law graduates that we were sending out into these places of work were fundamentally unprepared for the world of legal work. And by this I mean they were unprepared for legal professional life. The big headline at the time was that lawyers cannot read, write, or count. This was a very severe indictment, and it was partly true. My problem with that was it was clearly market-centered. It was about producing a increased workforce for the corporate legal profession in particular, and it had no social or critical dimension to it. It was really about how do you produce more and more effective lawyers. In other words, the law firms didn't want to do too much overtraining of law students. They wanted law students, as the word goes, to hit the ground running. That was the word that they wanted. So they didn't want to do any vocational training. So we needed, apparently, in the few years we have students with us, to provide them both with legal knowledge, but also with the necessary technical and social skills to be a good legal professional. So I had a serious problem with this idea. I did not believe that, and still don't believe, academics should be beholden to the profession. And I think we should use our opportunity as teachers to begin to transform, as it were, the thought structures of law. So my understanding was that the crisis in law and in legal education was not that our students cannot read, write, and count, and that is a serious problem. The deeper crisis was a crisis of justice. It was that we were living in a South African context, or we are still living in a country that has not addressed its historical crises and has therefore not addressed the living conditions of people and the problem of justice. So for me, my problem was not so much that students cannot read, write, and count, but it was that our students lacked critical literacy about the historical and social context that they were in. It was that although many students, especially in my neck of the woods, have a very strong technical or doctrinal understanding of the law, they didn't have a strong enough understanding of the moral, political, and cultural contestations around law, around legality. That's what we needed to provide students, in addition to providing them with legal education. So I've been thinking about the notion of critical legal education, and the idea of critical legal education takes directly from the work and thinking of someone like Paulo Freire, and the idea of critical pedagogy. I do want to say one thing about critical pedagogy that I've been trying to think about quite recently, and that is that we are not just teaching the oppressed in our classroom, unfortunately. We're also teaching beneficiaries of oppression. So in other words, we're teaching black students and white students, we're teaching women and men, and so forth. So the idea of a pedagogy of the oppressed, rather than being geared towards the idea of self-knowledge, as Paulo Freire initially thought about it, I thought you could use it as a method for bringing up critical issues in law and society. Questions about oppression, questions about domination, and questions about social exclusion, and place those at the center of how we understand law, legal rules, and their operation. So that's how I understood the idea of a critical legal education. I don't understand it as a pedagogy of the oppressed in that sense, because in fact I think we teach more of the oppressor than of the oppressed. There are aspects, I think, of Paulo Freire's work that might not be fully applicable to what we do. The second thing about the notion of a critical legal education, as at least I think about it, is that I've been trying and have tried to articulate a notion of a critical approach to legal education that is not the same as what in this part of South Africa is called transformative legal education. A scholar at Stellenbosch, Rio Quino, but also I think at UCT, Leslie Greenbaum, supports the idea that we should teach students to valorize the Constitution, to believe in the vision of social transformation embedded in the Constitution. For a number of reasons, some articulated yesterday, I don't think that's necessary, I don't think that's important. The idea of teaching students law is not for them to develop some kind of pathological attachment to the existing legal order, it's for them to be critical of any kind of legal arrangement and to always be able to see the dark side of law under any conditions. Okay, so I'm not saying students must disregard the Constitution, no, I'm just saying that it is not for me to teach them to worship the Constitution. And so I was interested in a notion of critique that would be subversive, as it were, of law and legality, and in particular, an idea of focusing on those voices and those communities and those perspectives that got left out of the dominant legal story. For me, those are black South Africans generally, but for other people, those would be poor communities, those would be social movements, communities of poor women that would be victims of domestic violence. So in other words, all the kinds of subjects and subjectivities that don't get counted in the official story of law. Because if you were to count them as central to the story of law, they would complicate this pristine picture of law as a tool for transformation. Because you also have to see law as a tool of violence, as a tool of domination, and as a tool of exclusion. So I'm not talking about transformative legal education, I'm talking about critical legal education. And here I'm talking about critique in the old radical sense of a way of seeing the social that goes to the root. In other words, that tries to apprehend the deepest, most fundamental organizing principles of that social order. In other words, that would bring to the fore issues around capitalism, issues around white supremacy, issues around patriarchy. Those would be central to how we convey our understanding of legal rules and the social impact of law. That's the second part of it. In some of the overly doctrinal forms of legal education, we don't talk about, Dennis made that point, the distributive role of law or the social impact of law. And it is important for students to understand that the way we reason, the way we think, and the way we approach law and legal reasoning, in fact, does have an outcome and does influence the thought structures that are available to lawyers and judges and legal advisors and so forth. Okay. The other reason I was thinking about a critical legal education is because studies are showing or are suggesting that more and more of our law students are not going into the legal profession as they used to. So in other words, more and more law students are seeing that there's more to do than to be a private legal professional, like to be an advocate or attorney. Some are becoming journalists, some are working for banks, some are working in NGOs, some are taking second degrees that have nothing to do with law and so forth. So there has to be a dimension of legal education general enough to also ensure that those kinds of students are well trained as well. So in other words, I wanted a non-technocentric, non-professional centric conception of legal education. So the title of this particular paper, I titled The Time and Space of Critical Legal Pedagogy, and I wrote it around the time of the student protests. And I found a wonderful article by Achille Mbembe, wrote an article called At the Center of the Knot. I was trying to think about what it means to be at the center of the knot, and he was suggesting that South African academics, South African intellectuals, if we still have those, I am not sure, were at the center of the knot. And to be at the center of the knot, in terms of what Mbembe was saying, was to be disconnected or unmoored, as it were, from the larger context that shapes law and society. So it's the kind of scholarship that's very humdrum. It has no sense about the intellectual and social context that it's operating in. It's also a form of intellectual thinking that is simply, that has no sense of the world and society we're in today. That is what it means to be at the center of knowledge. In other words, to be trapped in time, to have no sense that time is moving, things are changing, and that world history is constantly in the making. So another way to think about being at the center of the knot is to think about what it means when you're in the grip of the end of history, right? When you think nothing more can happen, nothing can change, nothing important or revolutionary is possible anymore. That closure of the horizon of thought makes it impossible to think about critical resistances and critical and new ways of thinking. So my suggestion was that legal education in particular, quite distinct from the other humanities and social sciences disciplines, is at the center of the knot. And we see this in many ways. We see this in the fact that we have still a largely white and male professoriate. So most of the senior academics are run about, shall I say, from about 46 upwards. Not a good thing, because apparently very soon we will need a very large injection of academics because we're simply running out of academics. The second problem about legal education was that, and students complain about it, but this is a fact, is that we've gotten law students in particular into a kind of rote learning. It is not unusual for law students to simply study by using past exam papers. It is not unusual for students to participate in a practice like spotting, which is like, what is the person going to ask? This might happen in other disciplines, but what's problematic about it in the legal discipline is precisely the sense that there's no other way to think about law. There's always one right answer, and law is eternal. Right? So this road learning produces this idea of law as fixed and eternal, which it is not and has never been. How you think about law changes what law can do. So that was problematic. And finally, still a very dominant formalist approach to law, or a positivistic approach to law, what we might also call a kind of classical approach to law. It's centered on the idea that law is determinate, law is fixed, law is objective, and tends to limit the kinds of teaching we can do. Okay, so I wanted to think about a form of legal education, a critical legal education, that could untie us or take us out of this knot at which we are at the center. To try and connect law and law students to the contemporary political contestations, events, and dynamics that structure our present. And I wanted to do this through what you might call a socially relevant and emancipatory pedagogy of law, that at once produces technically skilled lawyers, but also, and at the same time, produces critically literate, socially politically conscious, thoughtful law students as well at the same time. Many legal academics think there's a tension between the two. You either produce good lawyers or you produce good, as they've sometimes put it, philosophers. I don't think that binary holds. To understand law, to understand legal argument, and to understand the society in which law operates, you must have some understanding of the philosophical, the sociological, the historical, and even the literary. And so I thought that was significant for how we think about legal education. So I'm about to run out of time, but I'll say a few more things. There are many things I think legal educators must think about, and think about afresh. I have three for the moment. The first is we need to continue to develop in students what you might call a subversive orientation towards law. A subversive orientation of law, some people might also call it a bottom-up approach to law, is an approach to law that is composed not only of kings, popes, lawmakers, and elites, but also of peasants, masses, and the marginalized. Okay. So it's a story of law from the bottom, from those who've experienced its harsh underside, as it were. But the value of such an approach is that it moves away from the kind of early approaches which believe that there's some internal logic to law, and that all you need to be doing as a lawyer or legal academic is to justify the present legal arrangement. A subversive approach to law would show that law is a social contract that is historically contingent. That is to say, it is produced for a bewildering array of reasons, some of which have no basis in logic and simply are an effect of power and contestation, conflict and resistance. Okay, so I wanted students to also understand that those foundations of law are not based on some divine logic, but in fact are structured by the social reality in which law is based. So I wanted students to understand the distributive and cultural role of law. In other words, that law transmits cultural meanings, ways of seeing the world that shape human consciousness. I wanted students to see that you can challenge hegemonic legal concepts like reasonableness and ownership by showing their contingent foundations. That's a subversive approach to law. And Upendra Bakshi, a legal scholar in India, has made the point that we need to teach less of the technical law and more of what he calls the ideal law. And that's kind of what I'm thinking about when we think of a critical legal education. Less of the technical and more of the ideal. And once again, there's no tension or binary between them. Just want to say two more things. The first is that I think part of being subversive towards law is to be critical of fetishizing the Constitution. Many people say that's how you teach law. You teach law by telling students how wonderful and transformative the Constitution is. I don't think that's true. I think it's problematic, and I think on a deeper philosophical level, that's how you develop totalitarianism. You become attached to the present. I think that's problematic. Finally, I do think there's a lot in South African law that can be decolonized, but the conceptual itinerary of decolonization is of such a nature that I don't think you can necessarily decolonize a field of law. South African law as it currently stands is the law of the conqueror. So we would decolonize law by exposing law's relationship to colonial violence and to prepare for the possibility that African law might become African law and not simply customary law or the law of a few people in some sort of minoritized, faraway place. So just to conclude about critical legal education is that its technical consequences are that we'll have to think about how long we teach, what our relationship is to the other humanities disciplines and so forth. But the central idea of a critical legal education is that we should move away from a professionalized approach to law to precisely a critical humanities-oriented teaching of law. Thank you.